So, hi everyone. Today's session is on commercial trust law, and we're doing learning outcome 2 today. And my name is Shazia Khan. We're doing learning outcome 2, which is to understand the way in how trusts are used in commercial transactions and how issues are dealt with according to the norms of contract and trust law. Firstly, I'm going to just give you a summary of what we did in the last session, which was learning outcome 1. And there we looked at understanding the basic principles of equity as part of English system of law. So in learning outcome 1, we looked at modern trust drafting, principles and nature of equity, trust, tax, estate and planning. We looked at types of trust, which are bare trust, interest in possession trust, discretionary trust, accumulation trust, and mixed trust. We also looked at beneficiaries' rights, trustees' duties, and also equity and trusts. Things like fiduciary duties, duty of care, duty to avoid conflicts of interest for trustees, and duty to comply with the terms of a trust and being impartial. So we looked at 1.1, which was to analyse the mechanics of creating a trust, including the rights of beneficiaries. So we looked at intention, which is the main cornerstone of creating an express trust. We looked at certainty of subject matter, and we looked at certainty of objects. We also looked at the certainty of trust purpose and formalities. We then went on to look at transfer of legal titles, so legal ownership of the trust property and how it should be transferred to the trustees. We also looked at complying with statutory requirements, so any sort of legal requirements that you need to comply with, any sort of relevant legislation that you need to comply with to do with taxation or your assets. We also looked at the rights of beneficiaries, so the right to trust property, the right to information, and the right to enforce the trust. We then went on to look at their rights to inspect documents, the right to sue, and the right to benefit. We then looked at 1.2, which was to understand the functions of a trust device. And we looked at asset management, which was the main function of trust device to actually facilitate the assets and manage them. Asset protection, so how they serve as a tool for protecting the assets. We also looked at estate planning and privacy and confidentiality. We then went on to look at trust devices for tax planning purposes and for charitable giving, and trust devices for succession planning for businesses and special needs planning. We then went on to look at 1.3, which was to evaluate and compare types of trusts. So here we looked at bare trusts, the evaluation and comparison for them. We then went on to look at interest in possession trusts, evaluation and comparison for them and what they actually do. We then went on to look at discretionary trusts, where they actually grant trustees broad discretion to distribute trust income and capital among a class of beneficiaries. We went on to look at accumulation trusts, which looks at retaining income within the trust rather than distributing it to the beneficiaries. And we then went on to look at mixed trusts, and they are combination and elements of different trusts, allowing for like a customized kind of arrangement that cater for the specific objectives or beneficiaries' needs. So we looked at things in regards to them. We then went on to look at settler interested trust and how that involves the settler retaining certain interests or benefits in the trust, such as the right to income or the power to revoke or amend the trust. We then went on to look at non-resident trusts and how they are established in different jurisdictions. We then went on to look at 1.4, which was to evaluate the nature of respective rights and obligations of the parties. And respective rights, so rights and then obligations. We looked at what trustees' rights were to like possess and manage the trust property in accordance with the terms and conditions of the trust and the laws in place. We then went to look at their obligations, sorry. We went on to look at beneficiaries' rights and obligations within a trust, and how they have the right to enforce the trust and ensure that trustees fulfill their duties and obligations. We then went on to look at other parties that may be involved, such as professionals, such as lawyers, accountants, or any sort of financial advisors, and how they may have the right to provide guidance and advice to trustees, but don't have a direct obligation. So, you know, they may be able to advise on certain elements or certain terms and conditions and the law as well in regards to it. So they will be there to just as a guide. We then went on to look at the nature of respective rights and obligations, and how it's rooted into principles of equity, and how they have a fiduciary duty, which you know, requires parties to act with honesty and integrity and diligence, because it's so important that parties establish that relationship. We also went to look at how trustees have a significant role in managing and safeguarding the trust property, and the beneficiaries have enforceable rights to ensure that trustees actually fulfill their duties and not breach the duties. And that we went on to look at the rights and obligations of parties and how they may vary on the type of trust they have got, and the specific terms of the trust and how the law governs it in that jurisdiction. So in the UK, it may be different. In Canada, it may be different. In Kenya, it may be different. So it would apply to the law governing that country to follow the specific requirements of a trust. And it's really important that you follow the legal requirements if you want a trust to become enforceable, or you want to have certain terms within a trust. So it's up to the beneficiary to specify what terms they want within a trust. So that was learning outcome 1. We're now going to look at learning outcome 2, which is to look at understanding the ways trusts are used in commercial transactions, and how issues are dealt with according to the norms of contract and trust law. So the indicative context. So we'll be looking at commercial uses of trust, contract law and trust law, trusts implied by law, so resulting in constructive trusts, contract law terms and their interpretations, trust contract of appointment, liabilities and breach, equitable remedies. We'll be looking at provision in their contract of appointment and exclude liability for a range of defaults. And we'll also be looking at pension trusts and trusts and bonds. Key terminology. So we've got commercial uses of trusts. So you have trusts in commercial transactions, trusts for client customer monies, trust as a form of security, and trusts in collective investment schemes, and trusts for employee benefits. Number 2, you look at contract law and trust law. So the interplay between contract law and trust law, how they work together, contractual terms and their interpretation, implied trusts, resulting and constructive trusts. And then number 3, trustee contract of employment, trustees' liabilities and breach of duties, provisions to exclude trustees' liabilities. And then number 4, equitable remedies, which are available in commercial trust disputes. Number 5, specific trust applications, so pension trusts, trust and bonds. And then number 6, finally, which is certainty of intention, subject matter and beneficiaries, fiduciary duties of trustees, duty of care, and avoidance of conflicts of interest. And in your own time, there's a video there which is looks at what is a trust and how it works within the implementation of an express trust. So we're going on to 2.1, which is to analyse the context of commercial transactions within the framework of contract law, trust law, and equity involves understanding how these legal principles intersect and influence each other. So here's a breakdown of the analysis. So contract law in commercial transactions. So when we look at contract law, it's really important in any sort of commercial transaction. You know, in English law, a contract can be written orally, or partly written and partly oral. So however, it's best practice for any sort of business to ensure that all commercial contracts are in writing, as it reduces the risk of any sort of disagreements arising in future as to whether or not the contract exists at all. In English law, contract comes into existence when the following elements are met. So firstly, you know, we're going to go through this in a little bit more, but offer acceptance, there must be consideration, there must be intention to be legally binding, and there must be certainty of terms. So they are the formation of a contract. So we're going to, like, formation of contracts. So commercial transactions typically begin with the formation of contract between parties. Contract law governs the creation, interpretation, and enforcement of these agreements. So it requires parties to offer, accept, and exchange consideration to create legal binding agreements. So an offer would be where one party makes an offer of the terms on which the parties will contract on, and that offer is subsequently accepted by the other party. And there must be consideration, which is that the parties must have exchanged something of value between them, for example, the payment in money in return for goods or services. And then intention to create legally binding. So this is where the parties must intend for the contract to be legally binding. In a commercial setting, there's a presumption under common law that parties intend for their contract to be legally binding. And then the terms, certainty of terms. So this is where the terms of the contract must be sufficiently certain and detailed, otherwise they may not be enforceable. So it's really important that these elements are taken into consideration, because in most commercial contracts, the element of consideration is usually met where the parties must intend for the contract to be legally binding. So it's really, really important that these are taken into account when, you know, you are trying to draft a commercial contract. So the terms of the contract, as we mentioned, so contracts in commercial transactions outlines things like the delivery time. It could be, you know, the rights and duties. It could be these may include pricing, delivery schedules, quality standards, and dispute resolution mechanisms. So contract law ensures that parties' intentions are reflected accurately in the contract terms. Breach of contract. So if a party fails to fulfill its obligations, it may constitute a breach of contract. And contract law provides remedies for breaches such as damages, specific performance, or cancellation of the contract. And the goal is to compensate the non-breaching party for losses suffered due to that kind of breach. So, you know, these need to be taken into account, and the parties must ensure, you know, that the contract is complete and it's not lacking any sort of essential terms, and it's not certain, for example, drafting and the vagueness of it. It is a well-drafted commercial contract will meet the test for effective contract formation. So there will be no issues whether there's a legally binding contract or not. So, you know, it needs to be the laws and regulations need to be followed and are complex, and contractual parties should fully understand any agreement before they enter into it. Trusts in commercial transactions. So the use of trust structures. Trusts are often utilized in commercial transactions to hold and manage assets for the benefit of beneficiaries. Trust governs the creation, administration, and termination of these trust arrangements. It sets out the rights and duties of trustees, beneficiaries, and settlers. Fiduciary duties. So trustees in commercial trusts owe a fiduciary duty to act in the best interests of the beneficiaries. Trust law imposes duties of loyalty, care, and impartiality on trustees, ensuring they manage trust assets prudently and in accordance with the trust's terms. Enforcement of trust. Trust law provides mechanism for enforcing the rights of beneficiaries and holding trustees accountable for the breaches of any fiduciary duties or trust terms. Beneficiaries may seek remedies such as removal of trustees, damages for breach, or injunctions to prevent any sort of further harm. So if there's been any sort of breach of fiduciary duties, the beneficiaries can seek remedies. Equity in commercial transactions. In common law, the word equity is not a synonym for general fairness or natural justice, but refers to a particular body of rules that originated in a special system of courts. So it's literally, you know, in commercial transaction, the person who takes something in good faith and for the value without notice should have a good title, you know, so it's things that need to be taken in good faith. Supplementation of law. So equity operates alongside contract and law and trust law to provide remedies and principles that may not be available at common law. It serves as a mechanism to achieve fairness, as we've just mentioned, and justice in commercial transactions, especially in cases where strict legal rules may lead to inequitable outcomes. So it's really important that everything that is done in fairness. Equitable remedies. So equity offers a wide range of remedies, including specific performance, injunctions, rescission, and equitable estoppel. These remedies allow courts to tailor relief to the unique circumstances of each case and ensure that parties are treated fairly. The doctrine of estoppel. So equity includes doctrine such as promissory estoppel, which prevents a party from going back on its promise if the other party has relied on that promise to its detriment. This doctrine can have significant implications in commercial transactions where parties rely on assurances from each other. The doctrine of good faith owes its origin to the law of equity and can be traced back to the Court of Chancery's decision historically in the case of Carter and Boham. You know, it's really important that when you're doing something, you are taking into account under equity that that you are applying the law of equity, which is to do with fairness. In conclusion, in the context of commercial transactions, the interplay between contract law, trust law, and equity is crucial for establishing and enforcing legal rights and obligations. Parties must navigate these legal frameworks to ensure that their agreements are valid, enforceable, and equitable, meaning fair. Understanding how these principles intersect allows parties to structure transactions effectively and resolve disputes efficiently. So 2.2, evaluate the interactions. Evaluate the interactions between contract law and trust law. Contract law fortifies trust insofar as it provides grounds for confidence that another will perform a promise. If the law renders a certain promise enforceable, a person may trust, so have good grounds for confidence that will be performed. However, despite all the similarities, it should be noted that in contract, it is essential to consent of the contracting parties, whereas in the trust concept, consent is not a determining condition. This is because trust can be created by law. A trust be also created by perfectly unilateral act. So, you know, it needs to be taken into, you know, account that a trust is like a dedicated fund created for the benefit of a designated recipient, whereas a contract is a legally binding agreement between two individuals or entities in which each exchanges promises to give something of the value to another. Formation of trusts. So trust can be created through contractual agreements between the settler, which is the creator of the trust, and the trustees, those who hold and manage the trust property. While trustees are primarily governed by trust law, the formation of a trust often involves contractual elements such as the trust deed or declaration of trust, which outlines the terms and conditions of the true relationship between them. Express trust. In the context of express trust, the creation and terms of the trust are typically established through contract between the settler and the trustees. This contract may include provisions specifying the trustees' powers and duties, the beneficiaries' rights and the terms governing the administration of the trust property. Contract law principles govern the interpretation and enforcement of these contractual terms. Implied trusts can also arise through contractual arrangements, such as in cases of resulting trusts or constructive trusts. For example, when a property is transferred, subject to certain conditions for a specific purpose, an implied trust may be created to give effect to the parties. Contract law principles are relevant in determining the parties' intentions and the existence of any implied trusts relationships. Fiduciary duties. Trustees or fiduciary duties to the beneficiaries of the trust, including duties of loyalty, care, and impartiality. These duties are akin to those of contractual fiduciary and are enforceable under trust law. However, breaches of these duties may also give rise to claims under contract law, especially if the breach involves a violation of specific contractual terms or representations made by the trustees. Enforceability of trust arrangements. So while trusts are fundamentally equitable in nature, their enforceability often depends on compliance with contractual formalities. Trust deeds or declarations of trust must meet the requirements of contract law, such as an offer, acceptance, and consideration, as we mentioned earlier, to be valid and enforceable. Contract law governs also the capacity of parties to enter into trust agreements and the legality of the trust purposes. Modification of trust terms. So trust terms may be modified or varied through contractual mechanisms, such as trust deeds or supplementary agreements between the parties. Contract law principles of mutual assent, consideration, and intention to create legal relations govern the validity and enforcement of these modifications. However, any changes to the trust terms must also comply with trust law requirements and may be subject to court approval in certain circumstances. Remedies for breach. So breaches of trust, including breaches of contractual obligations by trustees, may give rise to remedies under both contract law and trust law. Beneficiaries may seek damages for losses suffered as a result of the breach, as well as equitable remedies such as injunctions, specific performance, or removal of the trustee. The choice of remedy and the applicable legal principles depend on the nature of the breach. So if it's quite severe, there may be, the severity of the breach may be a remedy that will, obviously, they will suffer a little bit more than others. And the parties' respective rights and obligations. So if they had more respected rights under the trust agreement, then the breach would be more harsh. In conclusion, so in summary, while trust law provides the framework for creation and administration of trusts, the interactions between contract law and trust law are significant. Contractual elements often play a crucial role in establishing trust relationships and defining the parties' rights and obligations and enforcing trust arrangements in commercial transactions. Understanding these interactions is essential for effectively navigating the complexities of trust-based commercial transactions. So there's a need to have a contract within trust law. So 2.3, explain how trusts are not bound up with a contract. So a trust is not a legal person, as a corporation is, and therefore it can be a party to a contract or sign a contract. The trustee is the proper signatory. The trusts are not inherently bound up with contracts in the sense that they can exist independently or contractually relationships. While contracts may be used to establish or govern certain aspects of trusts, the existence and operation of a trust are distinct from contractual arrangements. Here's an explanation of why trusts are not bound up with contracts. So equitable doctrine. Trust law is primarily grounded in equitable principles rather than contract law. The creation of operation is grounded, the creation of operation of trust are based on principles of equity, which are govern relationships where one party holds property for the benefit of another. These equitable interests, such as fiduciary duties and duty of trustees, to act in the best interests of the beneficiaries from the principles governing contractual relationships. Trust creation. The trust creation can be created through various means. Including by the operation of law, such as resulting or constructive trust, or by declaration. Of transfer of property by a settler to the trustees for the benefit of the beneficiaries. While express trust may involve contractual elements, such as the trust of deed or declaration. Deed or declaration of trust, the essential requirement for the creation of a trust is the intention of the settler to create a trust relationship rather than the formation of a contractual agreement. Parties involved. So the parties involved in a trust relationship are different from those in a contractual relationship. In a trust, there are typically three parties: the settler who creates the trust, the trustee who holds and manages the trust property, and the beneficiaries who are entitled to benefit from the trust property. While trustees owe fiduciary duties to the beneficiaries, their relationship is not based on contractual privity, but rather on the trustees' equitable obligations. Enforceability. So while trust, like we said, may involve contractual elements, as we mentioned earlier, such a trust as deeds of agreements between the parties, the enforceability of trust is not solely dependent on contract law principles. It's not solely dependent on contract law principles. Trusts are enforceable under trust law, which provides remedies for breaches of fiduciary duties, violations of trust terms, or other wrongs. Trust law remedies such as tracing, equitable compensation, or removal of trustees are distinct from contractual remedies and are based on equitable principles. The nature of obligations. So the obligations of trustees are beneficiaries in a trust relationship are primarily fiduciary and equitable in nature rather than contractual. Trustees owe fiduciary duties to act in the best interest of the beneficiaries and to manage the trust property prudently. Beneficiaries in turn have equitable interests in the trust property and are entitled to enforce their rights under trust law, regardless of any contractual relationship between the parties. So in conclusion, in summary, while contracts may be used in conjunction with trust to establish or govern certain aspects of the trust relationships, trusts themselves are not bound up by contracts. Trusts are distinct legal arrangements based on equitable principles with their own rules, obligations, and remedies that are separate from contract law. Understanding the differences between trusts and contracts is essential for navigating the complexities of trust-based arrangements in any sort of commercial transactions. So 2.4, critically analyze how trustees limit their liabilities. So critically analyzing how trustees limit their liabilities involves examining the various mechanisms and strategies trustees employ to mitigate risks and potential liabilities. Here are some considerations. Trust deed provisions. Trustees can limit their liabilities through carefully drafting trust deeds. Trust deeds typically outline the powers, duties, and responsibilities of the trustees, as well as any limitations on their liability. By including specific provisions that define the scope of trustees' duties and obligations, trustees can minimize any sort of ambiguity and potential disputes regarding their liabilities. A trustee is entered into a contract in its capacity. A trustee's liabilities under the contract will be limited to the property which the trustees hold on trust for the beneficiaries. Most trust deeds provide that trustee can use any property they hold on trust to conduct a business for the benefit of the beneficiaries of the trust. The limitation of liability clauses seeks to address this issue. Under the provision, a trustee will disclose and a contractor will acknowledge and agree that a trustee is entering into a contract in its capacity as the trustee of the trust, and a trustee's liabilities under the contract will be limited to the property which the trustee holds on trust for the beneficiaries of the trust. These provisions accordingly act as an important risk mitigant tool by limiting what assets a contractor can have recourse against to pay their debts. Trust deed provisions. So trusts can limit their liabilities through carefully drafted trust deeds. Trust deeds typically outline the powers and duties, as we've just mentioned. Exclusion of liability clauses. So trust deeds may include clauses that seek to exclude or limit trustees' liability for certain acts or omissions to the extent permitted by law. So, they'll have clauses in place that they feel that they need to have them in place so that the trustee will follow their, them clauses. However, the effectiveness of some clauses may be subject to legal scrutiny, particularly if the attempt to exclude liability for gross negligence, willful misconduct, or breaches of fiduciary duty. Insurance. Trustees can mitigate personal liability by obtaining professional indemnity insurance. This type of insurance provides coverage for legal costs and damages of duty or negligence in performance of their duties. Insurance can provide trustees with financial protection and a peace of mind if anything was to happen, although it does not absolve them of their fiduciary duties, because fiduciary duties is a legal duty that they must follow. They have liabilities and duties for any sort of acts or omissions or any losses. They must follow them, and that's a legal requirement. Appointment of professional trustees. So some trusts appoint professional trustees, such as banks, trust companies, or legal professionals, to manage trust assets. Professional trustees typically have expertise in trust administration and may offer greater protection against personal liability for individual trustees. However, appointing professional trustees may entail additional costs and may not always be practical for all trusts. The delegation of duties. So trustees may delegate certain administrative duties or investment decisions to a third-party professionals, such as maybe investment managers, accountants, or legal advisors. Delegating tasks allows trustees to rely on the expertise of professionals and can help them minimize the risk of any sort of errors or omissions. However, trustees remain ultimately responsible for their overseeing the delegated tasks and ensuring that they are carried out properly and following their duties. Acting within authority. So trustees can limit their liabilities by acting within the scope of their authority and in accordance with the terms of the trust deed and applicable law of that jurisdiction. Trustees must exercise due diligence, prudence, and good faith in the performance of their duties to avoid any sort of breaching any sort of their fiduciary obligations. Failure to act in accordance with their authority may expose trustees to liability for breaches of trust. So, you know, they must follow what their duties are, you know, and, you know, they need to be able to meet the requirements and not breach them. Trustees should regularly review and monitor it. Trustees should regularly review and monitor trust assets, investments and transactions to ensure any sort of compliance with trust terms and legal requirements. By maintaining accurate records, conducting periodical reviews and seeking professional advice when necessary, trustees can minimise the risk of errors, any sort of oversights or disputes that could lead to personal liability. Seeking court approval. In certain situations, trustees may seek court approval or directions to protect themselves. From potential liability. For example, trustees may apply to the court for any sort of approval of contentious decisions, such as selling trust property or making distributions to the beneficiaries, to obtain any sort of judicial validation and to mitigate the risk of challenge or liability. Trustees must not limit, exclude a trustee's liability or indemnify them for any breach of trust arising from the trustee's dishonesty, willful conduct or gross misconduct. A breach of trust occurs when a trustee contravenes the terms of the trust of the duties of a trustees. Trustees are jointly and severely liable for breach of trust to their beneficiaries where the breach has given rise to a loss. In conclusion, overall, trustees can limit their liabilities through a combination of proactive risk management strategies, adherence to legal requirements and prudent decision-making. However, trustees must act in the best interest of the beneficiary, and exercise due care and diligence in the performance of their duties to fulfill their fiduciary duties. Trustees are jointly and severely liable for breach of the trust to their beneficiaries where the breach has led to loss of a trust fund. A typical trustee exemption clause may read as no trustee shall be liable for any loss or damage which may happen to the trust fund or at any time or from any cause whatsoever, unless such loss or damage shall be caused by its own actual fraud. Even though a disclaimer may attempt to limit or exclude liability against loss for reliance of information given, if the information is found to be purposely misleading, it amounts to fraud for the trustee. If the trustee doesn't comply with their duties and responsibilities, finally, the trust beneficiaries can, like we said, apply to the court to have them removed to identify that they are not meeting the requirements and they're not following their fiduciary duties to comply with their duties. And it's really important that because it's you know, the court can also direct the trustees on how to correctly administer the trust. You know, it's really important that they follow the fiduciary duties. References. So the references, we've finished learning outcome 2 now. The references used for today's session is Hayton DWM, Mitchell, Underhill and Hayton's Law Relating to Trust and Trustees, DiIBL, Equity and Commercial Law, Hudson, Equity and Trust, Burks, Petra, Breach of Trust, Chambers, Commercial Trust in European Private Law, Davies, Introduction to Company Law, Good, Commercial Law, Haley, Modern Equity, Cambridge University Press, and Watterson, Breach of Trust. These are some really good references that will help you to complete your assignment. Meager, Equity Doctrines and Remedies, Orsted, Reynolds on Agency, Duke, Fiduciary Duties and Regulatory Rules, McLaren, The Law of Trust, and Palmer, Company Law. So please, we've finished learning outcome 2 now. Please refer to any ebooks and journals, any additional reading on Moodle that can supplement this unit, and also any further reading will be on Moodle. If you have any questions or any queries or would like any sort of issues in regards to the assignment, you need to email learnerwork@ukvarsity.co.uk if you have any questions, but please refer to Moodle for any additional reading and any ebooks and journals. Thank you for attending today's session. And I will see you in this next session, which is learning outcome 3. Thank you.